to bail and bond on the basis that these are young Kenyan citizens.
How old? When you say young, is how old?
I believe the fifth accused person is 24 years. 25 years. And the sixth accused person is 26 years old.
Yes.
They have young, and the fifth accused person has a young family, where he is the sole breadwinner. They should also to note they are normal citizens and they may not have any, they don't have any power to influence any investigation in this case. They are not a flight risk, and they are ready to cooperate with the terms issued by these courts. I'll leave it up to you.
Yes. Now, the state. How many of you are going to submit? You want to, or you want one to go after she's done, then you back up.
Yes.
So, Ms. Fuchaka?
No, but
Or
I think we are starting with
Mr.
JV Owiti.
JV Owiti?
Yes, then
Okay.
Mr. Lim will also submit.
But you know he speaks well. Yes. So the neighbors give way. Mr.
My lady, I don't have so much to say today.
Yes.
We have a response in terms of, it's difficult to say an application, but we have a response in terms of Article 49(1)(h) of the Constitution. And permit me just before that to mention Article 24, so that our response is by dint of Article 24. And our application, our response is based on Article 24 and 49(1)(h) of the Constitution. Is ours through the least restrictive measures, and we are urging the court that a denial of bail this morning is a least restrictive measure to limit the right to freedom and liberty of each and every one of the accused persons. And that is the tone that is used similarly under Section 123, capital A. and which I must admit my learned friend Bail has played a very important role. So that a look at the legal and factual matrix establishes a number of compelling reasons, and we argue that in the interest of justice, my lady, one more point, the public interest in this matter is not something that can be wished away. This court can take judicial notice under Section 60 of the Evidence Act to notice that this is a matter that has attracted immense public interest, and that in addition to all the compelling reasons that my learned senior Mr. Ondimu, OGW, will highlight this morning, the public interest, if there lacks any other that we have established, the public interest in this matter alone is sufficient enough compelling reason to deny bail. That's all from me, my lady. I will hand over to my very learned senior. Thank you. Unless there's a question for me.
No, not now. I'll ask later.
My lady, just add to add on briefly to what my colleague has pointed out. It is the duty of this court to weigh compelling reasons on a balance.
So take the pace of Mr. Owiti. I didn't pardon him because he knows the speed of the court. I am not video recording you, unlike my friends
because
here.
We are used to the advanced Kahawa law courts where we usually we are now back to
You transcribe.
Yes.
Congratulations on that for setting the pace. Yes, now I will take, yes.
My lady, the duty of the prosecution as at this point is to prove the existence of compelling reasons on a balance of probability as stated in paragraph 4.26a, paragraph 4.26a of the bail bond policy guidelines.
Yes.
My lady, the authorities that have provided and the bail bond policy guideline do enumerate what these compelling reasons are. As has been pointed out, that the list is not exhaustive.
Yes, please.
My lady, the first reason that we would wish to point out Central Police Station.
Oh, okay.
He was in detention
Yeah.
in relation to unrelated murder investigations.
Okay.
I would wish this court to address My lady, the last consideration is also on the issue of the victims' rights and public interest. My lady, we refer to paragraph 41, 42, paragraph 41 and 42, which captures in brief the views of the victims. This should be read in reference to Article 50, clause 9, on the need of the victims